everybody, and welcome to our YouTube channel. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, in this episode. So this is a recorded episode, but I'm gonna look at the most recent comments and questions, try to answer them, and try to see if we can get caught up and go through a bunch of them. Keep it interesting, and yeah, let's get into it. Let's see. So the most recent question is from a Vishal, and he or she says, and they're commenting on the recent video about what to do in your deposition, right? Because a lot of people have injury cases and they might have a deposition. You might have a deposition. So what do you do in your deposition? So Vishal asks, even if the other party was at fault and got cited, what is their goal in a deposition? So I guess he's asking like, well, why do I even need a deposition if the other car, let's say, was at fault, they hit me, the police came, they said, hey, I'm gonna give you a citation, a violation. It's so clear, this other guy's at fault, right? So why do we even need to take a deposition? Well, the defense lawyer hired by the insurance company will still want to take your deposition. Even if, let's say, liability is 100% clear, then what they'll do is they'll shift their attention to the issue of damages. They'll want to know how much treatment you got, maybe poke holes in your medical care, poke holes in your injury, see what they could do to lessen your damages, right? To pay out as little as possible. So their goal is always to defend and to make your injury claim worth less. So they're definitely going to want a deposition nevertheless. So I hope that helps. Okay. And then Cheyenne asks, I got in a car accident about a month ago. I was a passenger, and me and the driver both had 5 bulging discs and pain. Is our case worth anything? I think she means worth anything. Yeah, absolutely. I mean, if you were in a car crash and you're a passenger and you have 5 bulging discs, that's pretty serious. I mean, a bulging disc is when the disc kind of bulges out and it's not like, it hasn't exploded yet, right? The disc material is not leaking outside the disc, but that disc wall is bulging out. And bulging out of the disc wall could also cause that wall to then touch the nerve roots. And later on, it can lead to what's known as a full extrusion or herniation when the disc does explode and leak out. So it could be a serious case. I'd want to know how the accident happened, what's the liability. I'd want to know whether you're getting treatment, make sure you continue to get treatment. It's important to know where this happened, but absolutely it should be worth something, especially if you do get treatment and you build up the case. Then Buster Jr. Williams says, SOS, text me SOS. He wants me to text him, or I'm not sure what that means, but I can't really text because I don't have your number, but you could text me. How about that? 347-566-9595. And then we could get on a call, we could chat. Happy to help. That's what our goal is, helping serious injury victims and families. So we're here for you. Then Tiger asks, do you think the lawyers should send a demand package or just file? The lawyers I got want to go straight to filing. I want to ask you what you think, because you're truly the only lawyer I trust. Thank you. Oh, wow. Thank you. Thank you so much. Yeah, that's really a nice thing to say. Now, it really, I don't want to say it depends because that's the answer to a lot of things, but I guess the best way to say it is that the lawyer should do their own evaluation of the case. If the lawyer feels the case can be settled through a settlement demand package or settlement opportunity letter, then the lawyer should do that. Now, of course, the lawyer should consult with and have the consent of the client. But so it's all like whether the lawyer feels it'll work, basically, whether it'll prove fruitful. So for example, if let's say there's a minimal policy, like a $25,000 policy, and the injuries are like soft tissue, the lawyer feels, hey, I'm going to send this settlement demand for 25. If they give me like 15, 20, maybe I could settle the case, then go ahead and send the package. Usually for smaller cases, right? Now, if you have a bigger case, let's say you have $1 million policy and you have serious injuries like a surgery, you could send the package also. They can come back and say, okay, I'll give you 20,000, but is that really what you're looking for? No, right? You're looking for a much bigger payout. So probably in that case, it's better to just file a lawsuit. Now, even after you file the lawsuit, you could still discuss settlement. You could still send the same settlement letter. It's just now you have like two different, roads going. You have your lawsuit, and that's kind of like the end goal, right? If they don't settle, you have the lawsuit. You're gonna litigate the case, take depositions, do discovery, put it on the calendar, and then do a trial where a jury will issue a verdict, right? Render a verdict. It could be a big verdict. So that's what you kind of have over their head. That's your leverage. And then the settlement package is basically just asking, hey, do you guys want to pay us some money? They could say yes and give you a fair amount, but they could say no, or they could say yes and give you an unfair amount, right? Like a very, very lowball, like nuisance offer. So, So let's see what other questions. Chris Bell, how do you figure a fusion is worth $1 million in workers' comp settlements based on average weekly wage and a scheduled loss of use percentage of disability, and they cap your AWW if you make too much? I had a 7-level fusion with laminectomy. Just wondering, that has to be the worst case in a wheelchair paralyzed type of scenario. Yeah, well, I mean, my video is really not about workers' comp specifically. Like, some of my cases are work accidents, so there is a workers' comp component to them. But, the values I'm talking about are more like personal injury. So in New York, what happens is a worker could get hurt on the job, and they have workers' comp. Workers' comp pays their lost wages and their medical bills. And that's usually not, millions and millions of dollars, right? He's right. But then you also have a third-party lawsuit. Like, the most common scenario is in the construction field, right? You might have a worker could sue the owner of the building. They could also sue the general contractor. Now, they get workers' comp through their employer's workers' compensation insurance carrier, right? But then they have that lawsuit, that third-party lawsuit. That's the one that's going to settle for millions of dollars, because you have lost wages, you have pain and suffering, you have loss of enjoyment of life, you have non-economic plus economic damages. So that's going to be a big one. Yeah, workers' comp by itself, I'm not sure. I would defer to a workers' comp lawyer who only does workers' comp. So I hope that clarifies it. Okay, then Kathleen Holcomb Stevens asks, are you an attorney? I don't know, am I? I hope so. I had a 185-pound man attack me while I was sitting at a table, January 2022. I'm going in for surgery and finally soon, 9/11/23. It's an interesting question. I'm not sure what the question is. What does that have to do with being an attorney because the man attacked her? Well, the man attacked her when she was sitting at a table. I mean, I'm sorry to hear that. Now, I need to know more facts. The fact that a man attacked you, where did it happen? How did it happen? Is there insurance to cover it? Because sometimes with an assault, like if an individual just attacks another individual, it could be a crazy person, right? Just attacks someone. There's no insurance. No one else is liable. It's just a criminal case against that attacker. So, but sorry to hear that you're going for surgery. I'm not sure what the 9/11 is. Oh, maybe that's when the surgery will be, 9/11/23. Yeah, but feel free to text me. That sounds like a case where you probably want to get like a consultation, or, I don't even know where it is, so it's kind of hard for me to comment, but definitely text me. Let's see what other questions we have. Stacy Matthews, I've had cervical and thoracic fusion. I used to be a police officer, and the surgeries were due to being involved in a pursuit and crashing my patrol car. Unfortunately for me, in the state of Kansas, you only have 3 years to make a workers' comp claim. From what I've learned, many soft tissue damages can take a while to present. That's true. That's very true. So, of course, when mine started to show up, the state said, thanks for playing, but you're on your own. Thank you for your service. And then she goes on to talk about all the injuries and line of duty injuries. So I guess she can't sue because it's too late. Yeah, that's not fair. That's unfortunate. But I mean, unfortunately, each state has their own rules. And yeah, I'm handling a few of those cases for police officers, like line of duty. Sometimes we handle it for firefighters as well. In New York, they can sue. But there's also strict time limits. I mean, every state has the strict time limits, but I'm really sorry to hear that. Then Sadie Benfair. Hi, Mr. Frekhtman. Would you please explain to me how much money of my lost wages and personal injury I can get? Is that 2/3 of it or the whole amount? So in lost wages, you should be able to get the whole amount. The 2/3 is more like some other, I mean, in some cases it might be 2/3. Actually, sometimes in line of duty, that's what they give is like 2/3 of what they were earning because they stopped working. But in most personal injury cases, you get the whole amount. For example, I'm working somewhere, if someone's working somewhere, they're making a salary, let's say $50,000 a year, they get hurt, they can't work, they lose that, they don't work for a year, they lose that $50,000. As long as you can prove it, that it's from the crash, from the accident, your W-2s, your lost wages, you get that back, you should be able to get the full amount. Then PJ Dava says, amazing content, keep up the fantastic work. Oh, thank you, we will try to do that. Yeah, now by the way, if anyone has any ideas for videos, things you want to see, things you've liked in the past that you want to see again, or see something, maybe a prior video but in a different light, like some other issue that we haven't covered, let us know. We're here for you. Our goal is to help serious injury victims and families, help you, and we're basically here for you. So let us know what you want to see and we will do it. Then Aziz asks, hi, Mr. Frekhtman, how many settlement conferences before a case can be settled? So yeah, there's no like magic number. Usually, I mean, it depends on what type of case, so really, you don't even need any settlement conferences, right? Like the example we gave before, if it's just a small case, you could maybe even do a settlement letter and not even file a lawsuit and settle it as a claim. Now, if it's a bigger case, perhaps you do have to file a lawsuit, but they might say, okay, well, you have a clear case, like you have let's say, a serious case, liability's clear, we hit you in the rear, there's no question of fault, we see you have a serious injury, you have like a fusion, you have a broken ankle with surgery, we see it's going to be worth millions of dollars. Hey, here's an offer, we offer you like $300,000, come back to us. You give them a call the adjuster. Okay, well, 300's low, but how about 850? Okay, well, I can't pay 850, but I have 750. Okay, settle, boom, you're done, you see? And it's quick. That could be done in a few months, maybe, after filing a lawsuit, if you have that kind of case, like a real strong case. Now, if the case is weaker, they might offer you less or offer you nothing, and then it might take longer. Or if the case is good, but you think the case is worth so much, right? You try to get 10 million, no one's gonna, probably not going to just give you 10 million, right? They're going to say, well, I'll give you like 500,000 or whatever, 1 million, but not 10. So then you're going to have to go all the way to trial. Then you're going to need more conferences, more, and then probably you're not going to be able to settle. You're just going to need to go to trial. But a settlement conference is basically just an attempt to settle. You usually have a judge, you have the parties, their lawyers. It's not really anything that, like if you have, sometimes you could have 10. You probably won't have like 10 conferences unless there was a reason for it, right? Like, for example, you had one conference and the judge saw, hey, it's not going to settle today, but I could see this case settling eventually, so let's have a second one. And then the second one is like, okay, well, it almost settled, but maybe there's an issue with the medical reports. Let's do a third one. You know what I mean? Like, then they'll continue to schedule them. But if they see, hey, wait a minute, this guy's looking for 10 million and these guys are at $1, it's not going to settle. Why even schedule a second one? Just, that's it. Maybe the court will anyway because of rules, but it's not going to prove fruitful. So yeah. Okay, let's see what other questions we have. Lovem Callister says, what about an EEG after you had a car accident, when it calls you to have a mini stroke and small seizures after you had an MRI done? What is that EEG? What is this detecting for seeing if you have blood clots or what? Yeah, an EEG is more like electrical activity. It's more of an old school test. They've had that for a while. So it can help diagnose certain disorders, but it's not the same as a 3D MRI or like color imaging, like a diffuse tensor imaging or SPECT scans, PET scans. That's more of a newer technology. Now they have, I believe, a 7T MRI that could really show everything in the brain. So an EEG is more of an old school test. Oh, I see, and he was commenting on the one I did, the short video I did about SWI testing. That tests for blood on the brain. So Yeah, an EEG is different, but that's like a very basic test. Then Mr. Harrier says, love this to the video, how to use fear to increase injury lawsuit values. Yeah, that's an interesting topic. Maybe I'll do more videos about that. I like that. I like that topic about using fear and how fear, decides verdicts. I think it's very important because ultimately that's what, drives settlements is fear, right? The defendants fear you're going to get a big verdict. That's why they pay you money, because they don't want to pay more. And the plaintiff fears maybe losing or maybe fears waiting too long, and that's why they accept a settlement. Maybe fears an appeal, because an appeal could go on forever and then you don't know the result of the appeal. So that's like one of the ways you could drive settlement is through fear. Let's see what other questions we have. Here's a question from a Jonathan Barrows. He says, I've been through the mill. 2008 rear end accident, immediately had an L4, L5 lumbar fusion. Then straight after that, had to have a sacral nerve stimulator due to damage to the nerves controlling the bladder. Then a multi-level cervical fusion. Wow, that's terrible. Epidural nerve block, spinal cord stimulator, a year later removed as it didn't control pain, replaced with an a pain pump, and then a meniscus repair for a knee. After that, a total knee replacement. Oh my God, that's a really serious injury. I'm so sorry to hear that. And another lumbar L5 laminectomy, had to have the intercanal pain pump removed due to complications, chiropractors, physical therapy, epidurals, wow, carpal tunnel surgery, and was offered a settlement in 2021, which was declined. An EMG showed permanent nerve damage and radiculopathy in the cervical and lumbar spine. Do you think this is a serious injury supported by 5 years of ongoing medical treatment? Is a high value case given 100% fault? Yeah, absolutely. I mean, I think it could be worth many, many millions of dollars. Now, what you should do is find out how much insurance there is. I don't know where this is, which city and state, but absolutely that should be, and especially if it's 100% the other driver's fault, as long as they have enough insurance, that could be a monster case. That could be like that could be like a 5 to 10 million. I mean, I don't want to say exactly. I'd have to review the file. I'd have to know where it is, all the facts and circumstances, but absolutely, that sounds like a really, really serious case. I'm so sorry to hear that, going through that. Then Kathleen Vang says, my incident happened in 2021 and now it's 2023. My attorney said she's taking the defendant's deposition on the 8th of August, but now it's not until October. Why is that? And said defense like to settle cases at mediation. I'm confused. We have not gone into discovery. Not even gone into discovery. Yeah, I mean, depositions can be adjourned for a variety of reasons. Sometimes what the defendants do is they serve you a demand for like authorizations, right? And you give them authorizations, but then they say, oh, one of them I didn't get the actual records. I didn't, the doctor didn't send me the records, so I can't go to the deposition because I don't have all the medical records, so I want to adjourn it. That's one way that they adjourn. Another way is they just say, you know what, I'm busy. I have like something come up. I'm on trial or I have another case. I can't do it today. I just can't. It's my case. No one else knows it, so let's adjourn it. There's many reasons you can adjourn something, But it should go. If it's going to be adjourned too many times, what you could do is you could have your attorney file a motion to compel or motion to strike their answer. That's what it's called in New York, and compel them to go to the deposition. So, yeah. And then in terms of mediations, yeah, I mean, they could settle at a mediation, but you don't necessarily need a mediation to settle. You could also settle at any time. So, and then she says that it hasn't even gotten into discovery. So yeah, just try to get them to move it, definitely. But after a deposition, the defense and the insurance company has more facts about what happened. They know your story. So that's when they're more likely to settle, is after a deposition. Then Money Blake says, I have a question. My deposition was for August 9th. And it got postponed, but they didn't tell me a date, and it was this year. What do I expect? Yeah, I mean, try to find out the date as soon as possible. I don't like to adjourn depositions without a date, because then if you forget to follow up, if you forget to get the date, then it could just linger, right? The case is just sitting there. So it's always good to, like, for example, if they can't do the deposition August 9th, okay, how about August, 25th? How about September 1st? Get a date, you know? What's the point of adjourning it without a date? Now it's not even on the calendar and it's never going to happen. What if people forget, you know, secretary forgets and they go on to the next day, everyone's busy. Lawyer might go on a trial for like weeks. And then, yeah, before you know it, it's the end of the year, you don't have a deposition. So, and that's how cases sometimes get like what's known as marked off, and they're not even active. And then the lawyer has to go, oh my God, the case got marked off. And then they have to file a motion to restore. Now that takes 3-4 months. Now the judge just says, okay, you forgot about the case, it got dismissed or it got somehow inactive. I'll restore it, but it's just restored. It just means it's active again. It doesn't mean you have a deposition, right? So you have to call them, you have to schedule it. So if you already have a deposition, it's probably court ordered. So you probably can't even adjourn it without a date. I would never adjourn it without a date. I would always get a date. I mean, I don't know if you mean your attorney didn't tell you the date, but they have a date. That's different. You just find out the date. But if your attorney adjourned it without picking a date, that's not good. So you always want to adjourn it with a date. And then NOTCCP, I sustained a brain injury on school property in 2009 in Oregon. Yeah, I'm sorry to hear that. Now, a brain injury, 2009, that's quite a while ago, so you'd have to know if the statute of limitations is still active. Feel free to text me at 347-566-9595. If you were a child in school when it happened and you're not 18 or you just turned 18, you could still have a case because the statute gets told in infancy until you turn 18. So there's a lot of different questions here, how it happened, whether it was the school's fault. So I'll put my number in here so they can text me. And then here's a video about an opening statement in a $500,000 plus verdict. Oh, right. That was the one we did. That was the $535,000 verdict for a scar. This was the case where the girl was playing in the grass. She cut her leg. It was about a 5-centimeter scar. And she didn't get much treatment. You know, it was like 4 visits in 6 years. Just like some 8 stitches, then had stitches removed. It happened, I think, in July. Stitches removed in November. No treatment. Then 3 years later, she goes to a doctor because she's feeling a little numbness in the leg. Just a doctor, you know, like a pediatric family doctor. He kind of says it's a superficial wound, superficial nerve injury. Then again, no treatment for another 3 years. In 2022, that was the year before the trial, she goes to a specialist and he says that this could be the start of causalgia or CRPS. So then we ended up getting a $535,000 verdict. And Mr. Harrier says, damn good verdict for what it was. Yeah, I mean, I think so. It was a tough case. It's a tough case when people don't get much treatment, when there's no limited proof of what the injury is. And that case was also, the other thing about that case was we didn't have many witnesses. The case was, I mean, we spent a lot of time picking a jury, like 3-4 days, but then the case itself was just the plaintiff and one doctor, right? The doctor in 2022 who found the crypts. That's it. So it was kind of a quick case, and the defense just had their doctor, the defense medical examiner. And it was, yeah, $535,000. I actually did a webinar about that for another company called Trial Lawyers University. So that should be up there. It's more like for trial lawyers, but it's interesting. It was earlier this week, so that should be recorded too and up on their website. It's more like for lawyers to watch, but it was interesting. It was my first one with them, but now maybe we'll do another one on the $3.5 million settlement during trial that we got also. And hopefully we can keep getting some good results and keep doing these webinars. I like that because it's like continuing legal education, so you're helping other lawyers. And then also some of the techniques and some of the strategies that I used in that trial, I actually got from other, you know, webinars that I watched, Trial Lawyers University, as well as other groups. So everyone's always learning from each other, helping each other. That's good. That's really good. I love that. That's the way it should be. Okay, let's do 1 or 2 more questions. 333 Trauma says, I got hit by the wrong person, sadly. They had the minimum coverage and no assets tied to their name. My insurance was maxed, and after the lawyer fees, pretty much got stuck with a permanent injury and very little money. Yeah, I'm really sorry to hear that. But they say it sucks, but God is good to me and I'm happy to be alive. Yeah, I mean, your health is always the most important thing. Absolutely. Yeah. It happens. I mean, you never know, right? You get into an accident. Nobody wants it to happen. Sometimes it could be a 25 policy or even no insurance. And sometimes it could be a truck with millions and millions of insurance. But I mean, the only difference is with the truck, you're going to get more money if it's a serious injury. But nobody wants the injury to begin with, right? Nobody would ever want the injury. That's the whole point. That's why it's such a horrible thing. That's why when we go to trial, sometimes we ask for equal trade dollar value. What's the trade value of this, right? Nobody would want this, but if it already happened, if you thrust this into someone's life unnaturally and just ruin their life, what is that worth? That could be worth a tremendous amount. Okay. And then Melquan Tony says, congratulations on a spectacular presentation of your case. Thank you so much. And he's also talking about that same video with the opening statement that shaped the winning strategy. And Gail Ned says, thank you for the great content on your channel. Thank you so much. Yeah. Glad to see you are doing well and helping these serious injury survivors. God bless you. Thank you so much. Mike Richards says, Attorney Frekhtman, thank you for another fantastic analytical video that teaches us how to think and react through personal injury lawsuits. You're a great teacher and lawyer. Oh, and he's talking about the video about, well, it's a Last Week Tonight episode that we did. Okay. Can you do a commercial truck accident case where a person does a lumbar percutaneous discectomy and cervical percutaneous discectomy? Oh yeah, for sure. Actually, we just settled one like that. That's a good topic. We just settled a case. I think it was a settlement of about close to $800,000 total. It was for 2 people, but it was a commercial truck accident. And I believe that one, or if not both of them, did a percutaneous discectomy. So I could do that as a general video about commercial truck accidents. See, I mean, like the thing is with a video like that, what you're really gonna look at with a case like that, what you're really gonna focus on is how did the commercial truck accident happen, right? Each commercial truck accident is distinct. There could be a truck accident with a truck hitting a pedestrian. There could be 2 trucks colliding head on. It would be 1 truck or a truck rear-ended a car. So a lot of it is going to be specific about how it happened, right? That's going to be very granular and specific. Now, a percutaneous discectomy, that's just a procedure where they remove the leaking disc. It's a striker decompressor usually. That's serious. We've had cases go for like over $500,000 for that. The most recent one was $800,000, but it was for 2 people. Yeah, I could talk about that one. That one's settled, but it was in a kind of a conservative venue and it was still really far from trial. So it was a good settlement because they avoided the risk of trial. They avoided waiting another like 3-4 years to get to trial. But maybe I could pull up that file and review it and do a video about this question in the context of that specific case, because that case is exactly this, you know, the same injuries and the same type of case. It was a commercial truck crash. Okay, but thank you for asking that. That's from a Mars Get who asked that question. Okay, so I think that's pretty good for now. We're almost at the half-hour mark. So thank you for watching us. Please like and subscribe to our channel. Let us know what questions you have. Let us know what topics you'd want to see in the future. We are here for you. Our goal is helping serious injury victims and families. We hope you are feeling better, and just like feel free to interact with us so we can help, because that's our ultimate goal, is helping. Okay, have a great day, everyone. Bye-bye.